The broadcast is now starting. All attendees are in listen-only mode.
Hello, everybody, and thank you for joining us today. And a special thanks to our esteemed estate planning attorneys and presenters, Lane Rushforth and Brendan Bybee, with the Rushforth, Lee & Kiefer law firm located in Las Vegas, Nevada. A couple of housekeeping items to everybody before we begin the presentation. You're going to be placed on mute during the webinar. If you have questions, we're going to be answering them at the end. So on the right-hand side of your screen, you'll see a command box. And so just if you would please just type in your questions or comments and we'll address them at the end. Also, this presentation is going to be recorded and we will be providing a copy to you. And lastly, a copy of the slide deck is attached. It's the right-hand side of your screen. It's attached, it's in the command box towards the bottom. And also we can provide you a copy of the slide deck if you'd like it. Just please let us know. So today's presentation is proudly sponsored by Peak Trust Company, formerly Alaska Trust Company. Peak Trust is a professional trust administration firm with offices in two of the top trust jurisdictions, Anchorage, Alaska, and Las Vegas, Nevada. We specialize in administration of all types of trusts, from asset protection to trustees IRAs. We offer quality fiduciary solutions with an experienced, knowledgeable staff that can assist you and your clients in achieving their financial goals. And our contact information is listed on the last page of the webinar for your reference. So with that, I'm going to turn it over to our presenters. Take it away, Lane.
I'm just going to say a couple of comments as we get into this. I began my practice of law when trust and estates litigation was kind of minimal, and there was more of a collegial attitude of different things. And the bottom line is that our topic today is talking about doing some proactive, preventative measures to shield against litigation. We are Nevada attorneys primarily, and so our take on things is going to be somewhat slanted to Nevada, but the topic really relates to everybody throughout the country. We're going to talk about the factors that have triggered increasing litigation, the circumstances and parties that are involved, and we're going to talk about some preventative measures. And then with that, I'm going to turn the mic over to Brendan to get us started.
Thanks, Lane. First off, in getting into this, I want to kind of talk about the background that we're in right now and why we are seeing an increased frequency of litigation. Right now, a lot of us are aware that the baby boomer generation, a large population, is now heading towards seniority. That just means there are going to be a great number more of estates that need to be administered, a great deal of wealth that's going to be passed on, and increased opportunities for there to be challenges in those estates and trusts. We also have a trend of increased time spent in long-term disability among that generation. And obviously, disability and incapacity are factors that also produce litigation and conflict. An additional change that we're seeing in this period of time is a decrease in what was formerly called a traditional family structure, that we have a more diverse family structures are more common. Therefore, we have more people who are involved with non-family members who are part of their extended family, or at least that they have to deal with in terms of step parents and step siblings and that kind of thing. So that also increases factors for litigation among this growing number of estates that are being administered. When you are dealing with conflict in estates and in families, where you can deal with any number of different conflicts, and things can arise for sincere or disingenuous reasons. And whenever claims are brought before a court and we're dealing with litigation, oftentimes you're dealing with parties who may be sincere or disingenuous, but among those disingenuous, they're always trying to couch those concerns and their litigation as being sincere so that they get the best take. And from a perspective of a judge overseeing these types of conflicts, there's a difficulty to determine the difference between someone who is sincere and someone who is disingenuous, dealing with factors of wanting to see that a settlor's intentions are being upheld, but also that those intentions can be verified so that they're not upholding the wrong intentions and going against those. That just creates a very confusing situation, a situation where people can be very manipulative and where things can go a number of different ways. And so regardless of whether there are sincere or disingenuous concerns, which you'll deal with both of those, we tend to try to deal with things that can to overcome those disingenuous concerns, because they'll generally overcome the sincere as well. But this is sort of the difficulty that we run into when we're litigating these kinds of matters. Circumstances that can prompt litigation, I'm going to go through a number of factors here. One of those is changes made in advanced age, near death, or during illness. You have a grantor of a trust or a person, a testator, putting together their will. When these things happen at an advanced age, there are greater concerns over their ability to communicate or understand their own intentions, whether they have proper capacity to accomplish those kinds of testamentary planning, and whether or not somebody else is getting involved and either accomplishing something fraudulently through them or unduly influencing them and causing them to do something that's against their intentions. When we have competing documents and oral promises are another concern, because you may have people that have expectations. Going back to some of these disingenuous and sincere factors, one of the big things that jumps up is surprise. And is it likely that somebody would be surprised? Well, if you have competing documents saying different things, and somebody has an old document or even one that seems to be contemporaneous that raises a different expectation, then that presents to them maybe a valid reason for bringing litigation or conflict. Oral promises that, again, cause somebody to be surprised at what comes out in a will or a trust can also cause them to feel justified in bringing a contest. Pattern changes, an individual who is suddenly doing something different than what they had done before, not just in terms of, they were separating everything equally, distributing everything equally to their kids, and now they're changing that distribution. They may be doing something else that's a little bit different. They may have seen one attorney for all their entire life, and then suddenly this last bit of planning they did with a different attorney. Perhaps they did everything formally beforehand, but now they've suddenly done something informal that's out of character. They may have executed it in a care facility, and there may even be statutes that apply to that raise legal presumptions as to the validity of that planning that they've done. All of these things raise concerns that people can point to when they're bringing a contest. The parties involved, going back to that first slide and dealing with different family structures, the parties involved can prompt litigation. You can have a neighbor or a caregiver, whether that's a family caregiver or an outside party that's the caregiver, that suddenly they're in as a beneficiary or as a fiduciary, and they have some authority or some power here. Those things can cause surprise. Those things can cause some resentment and conflict, and that can be both reasonable and, in some cases, just arguable, so that there's cause for a contest. Sibling rivalries are common to play out in the course of an administration of an estate or a trust. It's generally unlikely that previous patterns of conflict within the family are not going to show up in the course of an administration. When we're dealing over of how much is being distributed to each member of the family, that raises conflict. If there are parties who are given authority and they get to play out their well settled family patterns of behavior, or if there are particular assets that people fight over. such as a family business or a favored piece of real estate. Family businesses are easy to raise conflict over because there are often different members of the family that are involved to different extent in that business. There may be some who have put in a lot of time and built that business up, and there may be others who, though they may not see it that way, have mostly just benefited off of that work. And so it can be very difficult to figure out how to divide that in a fair way or in a way that is not going to generate any kind of conflict. So obviously the family dynamics are common areas to raise litigation, and those are only increased oftentimes when it's involving a broader, more diverse family beyond just a nuclear family. So that goes to the next one, the new spouse and blended families. You can have a non-parent that's a surviving spouse, and that can raise a lot of conflicts. They can be a trustee over the fund, and the non-related children can have obvious concern over that and mistrust over how that's handled. It could be that their inheritance is deferred because the new spouse is essentially contemporary with them. And so they may not be entirely disinherited, but their inheritance is so far deferred that whatever is left by the time that the spouse passes, they're either getting very little or their children are getting very little. And you can also have a factor where that spouse has some power over what happens with the inheritance, that they can disinherit the unrelated children in favor of their own children, which may be common with the deceased spouse, but in any event, there are members who are left out. There can also be substantive changes that prompt litigation. This would be very common that we talk about unequal shares. You've got kids and everything was distributed equally. Suddenly, one member of the family is getting more than everybody else. There may be reasonable reasons behind that, regardless of whether they're reasonable or not. There may be reasons behind that, but it can be seen, one, as being suspicious, and two, it can be seen as a parting shot that is hard to swallow. It seems like just money on the one hand, but on the other hand, it can be very personal for the person who is suddenly left out or largely left out, and they can be in a state of disbelief. And again, that can be sincere, or it can even be disingenuous, where at least they can pretend that they're shocked by it, and bring that claim. And good luck to the judge trying to decide whether they're sincere or not. Fiduciary changes bring on the same kind of concern. You could have a close family member who was named, who everybody knows and trusts, and that could shift. It could shift to a child who is closer, who may or may not be exercising undue influence, closer geographically, I mean, and that can be a sudden change. It could be, in some cases we see where a family member who was previously distrusted is suddenly in good graces and vaulted to the top of the heap there, and everybody else can be a bit surprised. Maybe because that person is exercising undue influence, and maybe just because it's happening outside of everybody else's purview, and so they don't understand the reasons, they don't understand why it's happened, and to them it appears suspicious. So these are all sort of situations that can prompt litigation and give somebody reasons that can at least be arguably valid, whether they're sincere or not to them, and are common bases for litigation. I'm going to pass this over to Lane for the next section.
Good. Now, while the beneficiaries that have been somehow surprised or feel that it's fair, they want to say it's not fair or somebody getting cheated. But when the attorneys convert it into litigation, their most common legal basis is that the person making the will or trust, the settlor or the testator, lacked the mental capacity to make the document. And the standard of care depends on the type of the document. You'll see a lot of writing in various, both in the treatises and in the court cases, where they talk about testamentary capacity. And testamentary capacity is the capacity to make a will. And there were three prongs to that in the common law. The testator needed to be aware of the nature and extent of his or her assets. He or she needed to be aware of their family and friends, what the law calls the, quote, natural objects of their bounty, close quote. And they needed to understand how they wanted their assets distributed, and they needed to understand the document and the consequences of the language in the document. Now, along comes another phrase called contractual capacity. And in some jurisdictions, the capacity to make a contract is different from testamentary capacity. But the main difference was really the capacity to understand the nature and impact of the document being signed. And in more recent cases, these two concepts of testamentary and contractual capacity have kind of blurred into basically one standard that requires that the person have sufficient capacity to understand the document and what it does and the legal impact of it, not in terms of the minutiae legalese, but in terms of the general idea of how their assets are to be distributed. And so the less complex the document, the lower the standard would be, and the more complex the document, the higher the standard would be. And in Nevada, our courts have mentioned both testamentary and contractual capacity in relation to trust, and they've just kind of blurred, and it's hard to really say that we have a distinction anymore other than the fact that you need to understand the document. So that's the first kind of idea of the challenge that comes along, is they didn't know what they were doing, and they didn't have sufficient medical capacity, and then we get into medical testimony about their mental health and whether they're legally competent to do what they were doing. Even if they're competent, the next line of argument is that there was fraud, duress, or undue influence. Fraud is pretty straightforward. Somebody was making a decision, signing a document based on an intentional misrepresentation, a misrepresentation of an important fact or factor. Duress, we always worry about duress as somebody, this is particularly important in the caregiver scenario, where sometimes a person is willing to be more generous to the caregiver because they're afraid that they're going to pull the plug. They're afraid they're not going to give them their medications. They're afraid. And the same thing's true with, I think, emotional duress, where you have a child who is basically putting pressure on mom or dad in their older years, saying, you don't love me anymore, you got to show me, and look at all the things I'm doing for you. And they start putting pressure and duress on them. And sometimes there's a little bit of a coercion factor in here where they really don't feel like they have a choice. And then there's undue influence. Undue influence, I put a little quote here from a Nevada court case. Quote, it must appear either directly or by justifiable inference from the facts proved that the influence destroyed the free agency of the testator, quote, quote. That means that, at least in Nevada and other states that follow this standard, is that influence is not illegal. Influence doesn't invalidate a document. It's undue influence where there's so much pressure, so much coercion going on that they're not acting in their own mind. They're not acting with respect to their own desires. They're basically having somebody else replace their agency with their own. And then in many states, we now have a lot of dealings with the presumption of invalidity. Now, the old common law always said that if there was a position of trust, like a family, a business partner, a trusted advisor, and there was some kind of a position of trust, and you end up doing something that gets you favored more than others, there was a presumption of invalidity. Nevada and other states have codified that to some degree, and that is one of the things that we're going to try to deal with in terms of what we do to overcome these challenges. Is if there is a presumption of invalidity, what can we do in advance to overcome that presumption? I'll turn it back to Brendan now.
Thanks, Lane. I'll get control of these slides again. Obviously, planning can only be done when the person who is doing the planning is alive and has mental capacity. So the best time to do planning is now, before an event occurs that would cause any question. But also, there are many things that can happen during a person's life, and if somebody has an event that causes some reason for a decline in their mental capacity, the best time to get the planning done is as soon as possible. Now, from a planner's perspective, they may not have much control over that. They don't know when the client is coming in. They don't know, especially if it's not an existing client, they don't know when an event has happened and aren't there to advise them to rush in and get the planning done. But to the extent that you can advise somebody to get planning done now, it's much easier to plan to overcome the issues of declining capacity the earlier you get to it. The next thing to do is planning privately, and this comes down to the issue of undue influence. So the previous slide was about capacity. This is about undue influence and who's involved in the planning process. The main idea is when litigation, when a contest is coming before a judge, the main idea is that the settlor's intent, the testator's intent, is what guides and is what is ultimately supposed to be upheld. And so to the extent that other parties are involved that raise a question as to whether or not it was really what is in the documents represents what the settlor or the testator's intent is, there's a question there. And we want to avoid any of those questions. We want to avoid any disingenuous implication that somebody else really was driving the planning. And so planning privately with the advisor that is preparing documents is the best way to avoid those implications and those issues. Any participation by a beneficiary, whether that's in a planning meeting, whether that's even in choosing who the counsel is that the client goes to, those things can raise questions. If the beneficiary who is receiving an increased benefit that otherwise than what they would be expecting, or other than what was in previous planning, if they're choosing counsel, if they're paying for counsel, if they're involved in any of the consultations, if they have parties involved as witnesses that are favorable to them, any of these connections can, even if not being sincerely held questions, can raise arguable questions, and that can cause a lot of disruption and a lot of cost to the estate, whether or not there is really any undue influence involved. And so avoiding arguments of undue influence is important, and planning privately is an important way to do that. Professional planning is also another key. The more formalities that are involved, the higher the hurdles for the client to jump over to get their planning done, the more obvious investment they have, and the less likely it is that they've gone to all of this trouble simply to do something that is contrary to their intentions. So you have that aspect of it. You also have an increased confidence, and that's ultimately what we want. Is we want a judge who is presiding over a contest to be able to have a level of confidence that the planning reflects the client's intentions, and you have an increased confidence that the client understood their options, understood the testamentary factors, the natural objects of their bounty, and understood when they were doing a distribution, making any kind of planning that was contrary to what otherwise would have been expected. The professional planner can explain those implications, can warn them of things that might be misread, and can make sure that they understand those terms, and also are better at making sure those intentions are accurately conveyed in writing. Somebody doing their own plan, if anybody's ever had to preside over a probate of a holographic will, or one that was handwritten by a testator, you can see how inartful many of their statements are and how much confusion there can be in those cases. And professional planning, in the best cases, avoids that, and in most cases will do a much better job than the person themselves. You also get the fact that the professional planner has a reputation, or should have, or may have a reputation, and their license and their position as a professional lends credence to the documents, to what the client has done, and they're also a witness to the client's capacity, as well as as the client's expression of their own intentions. And being able to rely on that, it makes it harder to overcome any claim that the person didn't know what they were doing and didn't intend to do what they did in their documents. And you have an increased, with that experience, with that education that person has and their expertise, it's much less likely that there's going to be a technical issue that would avoid the validity of the documents because they have an issue of execution or something like that. So professional planning, it overcomes a lot of issues. In that, and direct client contact is an important sort of best practice for the advisor. The more direct your contact with the client, the fewer issues there are as to, do you know who else was involved here? Do you know that the client understood what you were explaining to them? When you have face-to-face contact, that's obviously the best situation. If they're in your office, face-to-face, you get to see the look on their face as you explain an option or tell them that something that they're considering might be hard to defend or might be easy to raise questions about. You can see if they're misunderstanding or confused. You also know who's in the room. When they're there with you, you know who's in the room, and you know if there's somebody else who's influencing them. In many cases, it may be best to ensure that maybe they're not even brought to the office by somebody who's going to have an increased benefit. And in any case, if they are brought to the office by somebody who may benefit from their planning, that they leave the office, that they're not even outside the door where they might be able to overhear, or where the client might have a fear that they're going to be overheard, and where those intentions are going to be revealed, and where they might be uncomfortable being completely open and honest. The other issues you have is direct client contact with an execution. If it's done in your office, you know what formalities have been have come into that execution. You're able to see the client actually signing the documents, and you know that there are not parties there who might be sort of cheering on this and benefiting from it. So when you can't have client contact, because obviously there are different situations, and the client has a level of control over how their representation is handled, then as a best practice for your own good, you should look to other ways of ensuring that there aren't other parties involved, and house calls might be necessary to ensure that you can verify that what the client is asking for and that it's their intention to do so. There are also at the drafting level, things that you can do to ensure that the challenges to the documents are going to be less effective. Declaration of intent is one thing that can be done that can certainly for people who are sincere in bringing challenges, that can give some context so that when there is something surprising, they get a context for why the client made that decision, and maybe are less likely to bring a contest, because even though they were surprised by it, now they have an understanding. And being sincere, they don't really want to cause trouble. They just want to make sure that what the decedent wanted is what is being done. For other parties, that it maybe makes it more difficult for them to raise those questions, because there's an explanation for why something was done, and so it's harder for them to argue that there was a mistake. Now, it's also can be a little bit tricky when you get into those issues of raising intent and explaining why something was done. You have to be careful about giving some specific reasons, especially when it might raise an issue of a mistake of fact on the part of the client that somebody might use as a wedge to bring a contest and overcome some planning that was done. The next thing is, when you're drafting clearly and accurately, if you go for the simplest way to express what the client wants and avoid all unnecessary complication, it's much less likely to create issues or create circumstances that can be brought up as something to attack. And so whenever you're dealing with a client, you want to counsel them towards the simplest way to accomplish their goals. In some cases, moving them away from complicated structures, and then when you're drafting it, making it as simple and clear as possible. Another way to help avoid conflict is the interorum clause or the no contest clause. Basically to raise the stakes for a person bringing a contest and give them some risk for what they're doing. Disincentivize litigation for the person who stands to lose something. Some clients think there's some magic to the $1 disinheritance. Leaving them $1 has some magic effect. Planners with experience know that that's not true. What you really need to do if you want to keep somebody from bringing a contest is they have to have at least enough to hurt if they were to lose it based on bringing a contest. So basically you want to use these in a way that's going to disincentivize litigation, and for those with a vested interest, a no contest clause will have some teeth. You also want to make sure that when you're drafting these, you draft them carefully. You might go beyond a simple no contest clause, because in many cases these are only going to be strictly construed by a judge, and most judges do not want to be the person who or do not want to feel like they're the person who disinherited a party from an estate, and will go to great lengths to avoid enforcing a no contest clause. So drafting it to limit a judge's ability to not enforce that is a critical way to make sure that these clauses have some teeth to them. Conditional distributions, drafting in a way that makes those interests non-vested until that condition is met. That might be a way to overcome a jurisdiction where a no contest clause would not be upheld. That has to be drafted in a skillful way, because there are ways that it can be done where it may still be disallowed because it's too close to the no contest clause, but this is a way that can be added to the no contest clause language to make it more effective. Another party here that can cause problems are fiduciaries, and so I want to bring this up because many of the conflicts that we see are between beneficiaries and fiduciaries, and oftentimes it's because family issues are being played out within the course of an administration, and that's whether or not it's a sibling or an uncle or some other party. They have a history that they're bringing to the table, and it's a common issue for litigation. Having a third party come in, and especially if they're a professional like Peak Trust or another trusted fiduciary, it can overcome a lot of the problems. It can avoid the cost and expense of mistakes that are made by non-professional fiduciaries, and can be a great way to avoid extra cost and see that your documents are enforced.
Before we move off of what Brendan said, I want to add a couple of comments. I want to reinforce the fact that there's a lot of nuisance litigation out there, and the more that we can do to basically make it unpalatable for an attorney to take the case, the better off we are. And I think that is done by giving something that they would, where it's very difficult for a contingency fee lawyer to feel good about taking a case. Another thing that I want to enforce, but I'll also add to, is reinforce, is that we just really don't want the primary beneficiaries of an estate to be the ones that are manipulating what's going on. But I do want to say there are times, once the estate has been designed, once everything's been done, there are times where you do want the family involved, such as in business succession planning and coordinating estate planning and doing different things. And so there are a lot of times where you have ongoing businesses and some of the family members in the business. It's okay to have meetings with those people, but they need to be, you need to make sure your meeting excludes them, and so that you make sure they're not driving it. As long as they're not driving it and they're cooperating and doing it, those are proper parties to a meeting with the attorney and making sure that it's done. Brendan already mentioned proper document execution. The key thing is that I've always told our staff here, and particularly the notaries, is that you're not going to remember every single execution that you participated in. But if we always do it the same way, by the book with no exceptions, then you can testify to that. You can say it was our protocol that we did this, this, and this, that we had the witnesses in there, that we had the notary, we had this and that and the other, and we never varied from that protocol. That's important to be able to say. So you establish a protocol and you never vary from it, and that will help you in your defense of a document. When it comes to undue influence and particularly lack of mental capacity, mental health is a key issue. Are they legally competent? Do they have the ability to understand the documents? And are they susceptible to undue influence? Because sometimes people in their older age they're not necessarily incompetent. They can still sign legal documents and do things, but they are kind of subject to suggestions and things from important people. And you get into the thing where it's easier to coerce somebody that's more susceptible. At a minimum, if there's any hint that there's some kind of mental health issue, you want to have some kind of proof that we have discovered and tried to make an attempt to discover their mental capacity. Kind of the minimum standard is to do the mini-mental examination or the mini-cog. I like to do both, but those really have very little evidentiary value because they're very superficial. They don't go into detail. There's no real analysis or assessment. And if you really want to have it done right, don't just have an affidavit from the MD that sees them every day. We had a case last year where a client came to me. He was leaving his home, which was his most significant asset, to his caregiver. And I said, we've got to have you do a mini-mental. He refused. He went down to his primary care physician at the Doc in the Box store and had him sign a document that says he knows what he's doing, has testamentary capacity. And he used those words. I don't think the doctor even knew what that meant. But I ended up in that case not participating in that. I chose not to because I wasn't sure he was doing the right thing. I mean, his children, and he had several, were going to get very little of what was left, and this caregiver was going to get the bulk of it. And I just didn't feel good about it. Now, do I think that's a standard of care? No, I think that's a best practice issue. But another thing is to get a board certified forensic psychiatrist or a psychologist involved and let them do a full workup and prepare a real assessment report so you have a true psychological assessment as opposed to just a quickie little affidavit. In the case where there's just a question of whether or not there's undue influence or whether or not there's some kind of lack of capacity, sometimes it's good to get a second legal opinion. In Nevada, we have a procedure for doing a certificate of independent reviewer and have a second attorney meet with the client and go through the assessment of the capacity. Are you aware of the nature and objects, nature and extent of your assets? Are you familiar with the natural objects of your bounty, and do you understand this is what you're doing? And I have served as an independent reviewer and gone through with people and say, this document says this. It seems a little strange, or you know, and I just verify that this is what they want. Video recording is a fun thing. I've been involved in video recording. I've never ever executed the actual signing of documents. I was always afraid that the witnesses would be looking off somewhere and that would be captured on video and they'd say, they weren't watching every second that they were signing. I didn't want to get into those weeds, and so I have never done a video recording of that. But I've done video recording in several cases where I've interviewed the client with nobody else in the room, or we've had a videographer there interviewing with them. And we've had, I won't go into the details, we don't have the time for it, but we've been able to show that to the court and be able to show a real vivid picture of their state of mind and why they were doing what they were doing. And it's been very effective. In one case, I never ever showed it in court, but I sent copies to all the nieces and nephews that thought they weren't getting enough. And guess what? None of them filed a dispute. And of course, we had a no contest clause that said that if you do dispute, and they were getting sizable disputes, but in that particular case, there were other people getting it that were non-family members. In many states now, you can get a pre-death declaratory ruling, and I encourage that. And it's a wonderful thing to have everybody come in and say, we want this document to be declared valid, whether it's a will or a trust. Now, of course, if you're going to make changes, the changes won't be covered by that court order, but the base document will. And so it's something that adds, all of these things add expense. All of these things will be subject to the client's willingness to do them and pay for them. But when you spend a few $1,000s to do these things, as opposed to hundreds of thousands of dollars in litigation expenses, it really makes a huge difference. In one big case I was involved in, we had the beneficiaries actually sign an agreement with mom for which she gave them cash as consideration so that it would be a binding contract, not just a no contest clause in the will or the trust, but a document that said, I'm being paid so that I won't interfere with my sisters running this business. And so we go into that. And in that one, with the consideration, I think it was done. And we also on that one had a court ratified. So those are kind of extremes, but those are things that you can do if there's a reason to do it. Now, all of us know the minimum requirements. We really want to go beyond the minimum. Number one, if you feel that something's not right and you don't feel good about doing that, maybe the safe thing is to pull away and just say, I'm not going to aid and abet in perpetuating a document that shouldn't be enforced. I think that we've had a number of cases where we've had special circumstances during an execution or during a client meeting where we've had the people in that meeting sign special affidavits. We've had it done concurrent with it, and we've had it done years later. The more concurrent it is, the bit more persuasive it is. But if there's been some special thing that happened during a meeting that reinforces the validity of the document, yes, they were asked about this specific thing, this seems odd to do, and they talked about it, and you had the witnesses or the notary or both, all of them sign a special affidavit about there. A medical expert present during execution is wonderful. If I had a situation, I do not normally do executions in a hospital or any other kind of medical care facility. But I made one exception in my career, and that was where the doctor was there present, and he signed a special affidavit of it. He wasn't one of the witnesses in the sense that he was a witness to the will, but he was a witness to the will. And he signed an affidavit about the fact that there was no medication, that their mental capacity was good, and it was he was there present in the room and whatnot. And anytime you're in a medical facility, you've got to take care to make sure that they aren't on meds, they haven't been having trouble, cognitive issues or anything like that. And then I also think it's really important to avoid doing things that are just going to ask for a contest. Most of the land now, I was in a multi-state meeting with people that are influencing legislation throughout the country recently, and electronic wills and trusts are huge. They're just really popular, and Nevada was one of the in the forefront of doing it. The bottom line is they're untested. Nobody knows if they're going to be recognized in another state. And if you've got property in multiple states, you've got to have documents that are going to be recognized in all those states. And people move, and a document that was done here may not be recognized. And the typical traditional rule is that if it's valid in one state, it'll be valid in another. But the problem that we have is that the rules are so divergent now that we're not sure the states are actually going to stick with that. And one of the most questionable things is this remote document execution. In Nevada, it's possible to have the witnesses in Florida and the notary in Texas and the person making the will here in Nevada. And we're doing it through electronic communications and all that kind of stuff. And if you read the statutes that out there, they're all really significantly different. And Nevada's, in my opinion, is totally the electronic wills issue. I mean, you have to have a custodian of the electronic document. You have to have so many precautions that it's just easier to do a paper document. And so I can see some need for this. I think it's going to be good in the future, but as for now, I think it's a risk to engage in that. Now, in conclusion, we are appreciative of your being and participating. If you look at this slide, the email address ep@rlklegal.com is there. That goes to me and Brendan, our assistant. And so if you have questions that don't get answered, feel free to send us an email, but be patient with us as we try to get to those answers. Again, I want to thank Peak for sponsoring us, and I'll turn the time back over to Deb.
Well, thank you, Lane and Brendan. So appreciate your time today, and great job with this topic. It's always an issue, especially we see it a lot as corporate professional fiduciaries and trustees. Of all the concerns you brought up, so I thank you for doing so. And then on the screen here, you will see contact information for Peak Trust if you do have any questions about our services, or basically how does it, or maybe just how does a professional trustee work. So give us a call or shoot us an email. I'm happy to chat with you. And again, thank you everybody for being with us today.